In today's video, we're going to cover the eviction process, how a landlord in Georgia would evict a residential tenant. Initially, we're going to cover the steps that a landlord would take in order to recover possession of the property and maybe money judgment against their tenant. And then we're going to cover some of the what ifs that might happen along the way and what you might do. Now, there's a lot of different what ifs, a lot of different scenarios that might come up. We're just going to cover some of the ones that are more common. To start, your lease has a notice of provision, and when a tenant is in default, in this case for non-payment of rent, then you would start by sending them a notice under that provision. Your lease may say that a certified mail is required. It may say that an email is required, but whatever it is, you need to abide by that and send a late letter or send them a notice that they are late and otherwise in default. It's not exactly required under the law when you're doing an eviction to send a late notice, but it is a best practice, and I would not want to go in front of a judge explaining that my very first step against my non-paying tenant was to file for eviction. The second part is the demand for possession. Now, all of Georgia landlord tenant law is under Title 44, Chapter 7. And if you want to look at what the law says related to evicting a tenant, you can go to 44.750 and read, sections 50 through 59. The however part is a lot of law is also case law, and the code will not cover case law. Just one example. Under the code, if you're evicting a tenant for non-payment of rent and they actually pay you the rent that they owe, then you have to accept it and cancel that dispossessory warrant. Under case law, that's now one time for every 12 months. And so if you had a tenant who was late and you started the eviction, they paid you the money, you've got to cancel the warrant. And they're late again 15 months later, but you don't want to accept the money, you want to get them out, you still, under the law, because of case law, have to accept that money. But inside of 11 months, you would not. That's just an example that what the code says and what case law covers are not the same thing. So under a new provision under 44.750 was modified under the Safe at Home Act that was passed by our legislature in 2024. Not only do you have to make a demand for possession, but the way you make the demand has to include that you take the notice inside of a sealed envelope and you tape it, tack it, paste it to the front door or some other conspicuous place where the tenant has to see it, and you give them at least 3 days to pay the money that's due or otherwise cure the default that they have under the lease before you proceed with filing for the eviction. So after you've given the 3-day notice to vacate or pay, as we refer to it, because that's the way it's described in the law, then you're going to file for the dispossessory warrant. You can do that at the magistrate court for the county in which the property is located. In many cases, you can do that online. When you file for the warrant, you're going to have to check one of two things. Why are you filing? Non-payment of rent or something else? In other words, if the reason you're getting rid of the tenant is because they brought in unauthorized pets, then you started with your notice declaring them in default because of the unauthorized pet. You gave them an opportunity to cure the default. They did not cure the default. So even in this example, the lease might run for 10 more months. You're telling the tenant that you need to get out now because you would not get rid of the unauthorized pets. When the tenant does not vacate, you're filing this dispossessory warrant for holding over beyond the termination of the lease. So you've decided to terminate the lease. You told them to move. They did not. And that's the reason for your filing. So you get two different kinds of filings: non-payment of rent, everything else is in the holding over category. And then you've got two different options related to how is that warrant going to be served. If you don't understand how this works, then you could cost yourself a lot of time. If you ask for personal service, the benefit is if the tenant is personally served and they do not show up in court, then not only are you going to get a writ of possession, but you're also going to get a money judgment related to how much they owe you. On the other hand, if you ask for tack and mail, what would happen is the sheriff's deputy would go out to the property, or you could have a process server do it, but they go out to the property, knock on the door. If nobody answers the door, they literally tape it to the door, and the tenant has been served. Under Georgia law, that tenant has 7 days to answer that warrant, and on day 8, you could go back to magistrate court if there's been no answer, to seek your writ of possession. Again, this is going to vary on exactly how you get that writ on a per county basis, but that's the way the law is covered, is after 7 days, if there's been no answer, then you can get your writ. The issue here is you might think I want personal service. You might think I want to get a money judgment against the tenant. But if the sheriff's deputy goes out to the property, knocks on the door, the tenant might be inside and ignore it and not answer the door. This is not an arrest warrant. The deputy is not going to kick in the door to serve the warrant. The people didn't open the door. They were not personally served. And so it can cause a very long delay in your eviction process because you asked for personal service and the sheriff's office keeps sending somebody out there once a week or so and nobody ever answers the door. And so you're not getting a start date on your 7 days. On the other hand, if you ask for tack and mail, when the sheriff's deputy goes out to the property, they knock on the door, nobody answers the door, they tape it to the door, the 7-day clock starts ticking. So the best practice is to go with tack and mail. Once you have the warrant delivered, the tenant may or may not answer. And again, this varies per county. In most counties, if there's no answer, then on day 8, you can go back to the magistrate court clerk, confirm that there's been no answer filed, and try and request your writ of possession. In some places, Forsyth County, Georgia is an example, that their procedure is their procedure, and you've got to live with it. When you filed for the dispossessory warrant on the 3rd of the month, that warrant may get served promptly by the sheriff's deputy, but they go ahead and schedule a court date, in this example, for the 25th of the month. And it doesn't matter whether the tenant answered within 7 days or not. You're not going to get your writ of possession until the court date. And when you show up in court, then the tenant may or may not be present. And if they did not answer the warrant and they're present, or they did answer the warrant and you're going to have your hearing, that's when you're going to get your writ. And while the law may say one thing, the different county magistrate courts do things their own way, and you got to know how they do them in your particular county. So if you're going to go to court, our strong recommendation is always go represented by an attorney. You don't have to, but it's a very good idea. One of the challenges is you might own your property in an entity like a sub-S corporation or an LLC. Well, that entity is a legal entity separate from you and your person. And so under the law of Georgia, if you're going to magistrate court and your entity 123 Main Street LLC owns 123 Main Street, and you're trying to evict the tenant from that property, there is a Rule 31 document that you would get filled out in advance to notify the court that you, Jane Doe, are representing 123 Main Street LLC so that you can represent yourself rather than having an attorney represent your LLC. And if you don't do that, then you're going to get a lecture from the court, and you'll probably have to start your eviction process all over again. Once you've gone to court, assuming everything goes your way, then the judge issues what's called a writ of possession. Excuse me. The judge and the law are going to explain to the tenant that you've got 7 calendar days to get out of the property, and as of day 8 and onward, you're at risk for somebody showing up and literally ejecting you from the property. Now, how quickly that happens is also going to vary per county. And the closer you get to our state capital, the more likely it is to take a longer period of time. Just because you have the legal right on day 8 to exercise the writ, the only people that can exercise this writ are law enforcement officers that are authorized to perform law enforcement activities in the jurisdiction where the property is located. In other words, until recently, that was the sheriff's office. But that same 2024 legislative session also allowed for the sheriff to post the names of deputies that were authorized to execute putouts in that county. And if you hired one of those off-duty deputies at your own expense, then you might schedule your own putout. Well, that could still take a long time. And when I say a long time, day 8 legally might be 2, 3, 4, 5 weeks down the road before a sheriff's deputy is available to meet you and your putout crew at the property. Do not try and execute a putout on your own. That would be a wrongful eviction. But if you show up at the property and the sheriff's deputy removes any of the humans, you have to provide a put-out crew to remove all of the things. The sheriff is not going to stand there for hours while you remove all of their things and put them on the curb. Each county, and you want to check this in advance, is going to have their own policy. In some cases, they want to have 2 people for every bedroom in the house available so that they can get everything onto the curb quickly and the sheriff can move on to the next put out that they need to execute. But once that put out has happened, then you have had possession returned to you. Well, there's a lot of what ifs that might happen along the way. You file the dispossessory warrant, and then your tenant submits a payment. I already described that if they are submitting their payment in full for the first time, you have to accept it and cancel that dispossessory proceeding. If they're late again, then if it's inside of 12 months, you don't have to accept it. And if the idea is you want to recover possession of the property, then you do not accept it. If you're accepting the money, you're continuing the tenancy. So don't accept the money, continue with your eviction process until you've recovered possession. Then you can try and go after the tenant based on the amount that was due that they did not pay. What if you think the tenant has skipped? You go to the property, you find what looks like a broken down recliner and a bunch of trash on the floor. Well, the war story from 40 years ago is one of our resident managers at a small apartment complex found exactly that. The tenant had not been paying rent. We filed for the dispossessory warrant. We got the writ of possession, and when the resident manager went to look at the property, what they found was a broken down recliner and a bunch of trash that would fill up like one of those black contractor garbage bags. So they cleaned out the unit and put it back on the market to re-rent it. And 9 months later, not the tenant, but the roommate of the tenant sued, claiming wrongful eviction because we did not yet have legal possession of the property. The put out had not been fully executed. And that ended up costing the owner of the property $20,000 to settle it and make that go away. So the issue is, if you're going to shortcut the process, there's 3 ways, according to case law, that possession can be returned from the tenant to the landlord, and you've got a very, very solid refutal of any claim of wrongful eviction. One would be for all of the tenants, we're talking about all of the adults on the lease, turn in all of the keys and tell you, we are out. Not the one spokesperson for the tenant, but all of them. In a similar way, if all of the tenants named on the lease have signed a document saying, we are out, which is not the same as we plan to be out on Sunday, past tense, we are out of the property, then you have a very good refutal or rebuttal for any claim of wrongful eviction. And the third way is what we talked about before. You've gone to court, you got your writ of possession, the sheriff's office sent the deputy out, you provided a put-out crew, the sheriff's deputy removed any of the people, the put-out crew removed any of the things, you changed the locks, possession has been returned to the landlord. So you're not at risk for a claim of wrongful eviction. However, anything else falls into that category of you may be found guilty of a wrongful eviction. So what if you go out to the property and it looks to you as if the tenant has left? And in that first visit, you immediately start cleaning up and throw away their stuff. Well, later, the wrongful eviction lawsuit is going to claim that their priceless family heirlooms, their jewelry, their collectible baseball cards, their coin collection, all that stuff was taken by you when you didn't yet have legal right to retake possession of the property. So if you're going to shortcut the process, this is a technique. This is not some case law guaranteed thing, but it's been tested legally a few times over the years, and it's worked well for us. And that is, when you go to the property and it looks like the tenant has vacated, you do a move-out inspection, but you leave everything in place. You document everything with your camera and your inspection, including make particular note of, is there any food in the refrigerator and are the utilities still connected? And then you're going to wait at least a week over the weekend, and you're going to do a second move-out inspection. And the reason for that is if you just do the first inspection and then the tenant claims a wrongful eviction, the tenant's story includes, well, I was just one pickup load away from being out of the property, and then my landlord came and took those priceless family heirlooms, my coin collection, et cetera, and now you've got this big lawsuit to face. Whereas if you do 2 inspections a week apart, including over the weekend, then it's a lot more difficult for the tenant to claim that they left a bunch of valuables behind. Not only that, but our technique includes, once we do that second inspection and have determined that the tenant is really out of the property, then we would also bag up and hold in the garage, in a storage closet, someplace like that, all those things that the tenant left behind. We would turnkey the unit and put it back on the market. And then when we've got it re-rented, somebody ready to move in, just before the move-in, we would get rid of the tenant's stuff. And that way, in the meantime, if the former tenant ever decided to file a lawsuit related to wrongful eviction, we'd be able to document this week-long period of time that nothing happened. Nobody came back to get anything else. The utilities were off. And we document that we have kept all of their possessions for what could be another 4, 6, 8 weeks before a new tenant is moving in. And in all that time, they never came back and tried to get anything. And while we've had that sort of claim made by attorneys and their tenants over the years, every time we present all this evidence, the attorneys lose heart and say, never mind, this case doesn't have any legs, and it tends to go away. The final common scenario is you're evicting your tenant for non-payment of rent, and they file for bankruptcy. And under the bankruptcy code, what ends up happening is you have to have an attorney file a motion to lift the stay. If you think about telling a dog to stay, when a tenant or anybody files for bankruptcy, the first thing the bankruptcy court tells all of the creditors is stay, stop, nobody do anything until we have determined what they have and what they owe and who's entitled to what related to this. Well, under the law, there is no reason for a tenant filing bankruptcy to stay in the property. The lease itself is not an asset. The lease, a residential lease, is a usufruct, meaning that they have the right to enjoy the property, but they don't have any estate in the property. So the stay will automatically be lifted. Unfortunately, the law is the law. I encourage you to write your representatives and see if they can get the bankruptcy, which is federal law, amended so that the bankruptcy code has nothing to do with possession of the property. It only has to do with the debt of the tenant. But in the meantime, it will interrupt your eviction process. So what you'd have to do is, as soon as the tenant has filed for bankruptcy protection, then you have to hire your attorney to file a motion to lift the stay, which will happen, but it will take days or weeks, and it has bought the tenant more time. Once that stay has been lifted, then you're back to your attorney, back to magistrate court to finish your eviction process. Now, this is just a small sample of many of the things that might happen during an eviction process. Again, our strong recommendation is use an attorney who is an expert in landlord-tenant law and handles evictions on a regular basis. And it's just another example of you need to know what you're doing, because you could very quickly go from somebody who is owed $4,000 in rent to somebody who's being sued for $50,000 or $100,000, being accused of you put a family on the street wrongfully when you did not have the right to do that. So those are the quick steps in the eviction process in Georgia and a few of the wrinkles that can come up along the way.